Hello and welcome to this Maritime London webinar in partnership with Maritime London Foundation members Hill Dickinson. I'm Joss Standerwick, Chief Executive of Maritime London, and I'll be moderating today's session, exploring how dispute resolution responds to increasingly complex shipping markets. I think as the back catalogue of Maritime London webinars evidences, the shipping world is changing as we experience the confluence of digitisation, automation, decarbonisation, and consequentially, I suppose, an increasingly onerous regulatory regime. And furthermore, I think as evidenced in our last webinar, there is still widespread economic uncertainty as a consequence of the pandemic and longer term trends. And whilst these effects have been covered in regards to nearly every facet of the shipping industry, from financing to decommissioning, I think probably to my mind, up to now, the effects on dispute resolution perhaps have not been covered with the same level of scrutiny. I therefore have no doubt we're in for an interesting and informative discussion today. After a top-level appraisal of the current landscape provided by Tom Macey-Dare, QC, Barrister at Quadrant Chambers, Ben Goss, Maritime Arbitrator and Mediator, will talk on the potential utility of dispute resolution boards in a shipping context. And then we'll pass over to Lewis Moore, partner at Hill Dickinson, who will explore the evolving use of cross-examination. After the presentations, we will have a panel discussion where you will be pleased to hear you all have the ability to fire in questions to the panel through the chat function. Right, before we get cracking, I'll just run through some housekeeping. I'm sure we've all been on plenty of webinars now, but please do bear with us if we have any technical difficulties. We'll do our best to minimize background noise, but children and pets are notoriously difficult to control, so apologies for any interruptions. This webinar is being recorded and will be made available to all the attendees through a follow-up email and also posted on our YouTube channel. And as I said, please do feel free to ask questions in the chat, and we'll look to get to covering as many of those in the Q&A that will follow the presentations. I think that is everything from me for now, and I'd like to pass the floor over to Tom. Tom, thanks very much.
Many thanks, Joss. So the title of this webinar raises the question, how is the shipping market becoming increasingly complex? And what is driving that complexity? In one sense, the drivers of change, the changes that we're seeing at the moment and that we expect to see in the coming months and years, are entirely new and unprecedented. But in another sense, they are simply the latest manifestations of factors that have been driving change and complexity in the shipping market for decades, centuries even. And those factors include regulation, new technology, and the state of the economy. And one can see that if one looks at the topic which is on everyone's lips at the moment, decarbonisation of the world economy generally, and of the shipping industry in particular, which contributes around 3% of global carbon emissions. The immediate driver behind the current push for decarbonisation is regulation and the threat of regulation. This has been talked about for years, and we've already seen some modest regulatory changes being introduced in relation to monitoring and improving the energy efficiency of ships. But right now, with climate change at the very top of the political agenda, we're really seeing the process of regulation gathering momentum. So, as many of you will know, the IMO has set itself a series of green goals, including a 40% reduction in the carbon intensity of shipping by 2030. That's compared with 2008 levels, and also a reduction of greenhouse gas emissions by at least 50% by 2050. And those are just the current goals. They're regarded by many as wholly inadequate. So yesterday, the Marine Environment Protection Committee of the IMO began its latest session, where it will be discussing new regulations which would require ships, both new and existing, to improve their energy efficiency continuously, year on year, through the use of the energy efficiency existing ship index and the carbon intensity indicator. Coincidentally, yesterday is also the day when Joe Biden touched down in London for his first overseas trip as president to discuss climate change with the G7 leaders in advance of COP21 later this year. In addition to what's happening at the IMO, there is currently a lot of talk of regulation on a regional and national level by the likes of the US, which is obviously no longer a climate skeptic nation, and particularly the EU. Measures under consideration include extending the EU's emissions trading scheme to cover shipping. And there are also increasing calls internationally for other market-based measures, such as a carbon levy on shipping. Now, these sorts of measures, if adopted, are likely to drive a lot of existing tonnage out of the market in the coming years. In parallel to these developments on the regulatory front, there's a huge amount of interest in new technological solutions to the problem of decarbonisation. And these include new IT and OT, operational technology, to monitor and improve efficiency of ships, new efficient designs of ships and engines, and of course the new greener fuels and propulsion technologies that we hear so much about these days, ranging from established ones like LNG through green ammonia, methanol, hydrogen, battery power, auxiliary wind power, and even serious R&D underway into nuclear propulsion systems using molten salt reactors. All those regulatory and technological developments are taking place against the background of a world economy and a shipping sector which is beginning to grow again as it emerges from the COVID pandemic. The shipping market remains fundamentally volatile, as it always has been, but there are signs that we are at the beginning of a new economic supercycle in shipping and commodities. And we see that rates in many sectors are increasing, especially for container ships, although there are special factors at work there. In this economic climate, major ship owners and commodity traders are publicly throwing their weight behind the new green technologies, encouraged, no doubt, by activist investors as well as pressure groups. And of course, many of the leading banks and institutions involved in financing the shipping industry have signed up to the Poseidon Principles to promote green ship finance. So as a result of all these factors, we can expect to see increasing investment and increasing adoption of new green technologies, along with the new infrastructure and supply chains that will be needed to support them. And at the same time, we can expect increasing burdens, both legal and commercial, being placed on operators of older, dirtier ships. So these emerging technologies, this developing regulatory landscape, and the economic situation are all new, but the overall pattern is not new. The shipping industry has undergone similarly seismic changes in the past. One thinks of the shift from sail to coal and then to fuel oil, from single to double hulled vessels, from high sulfur to low and ultra low sulfur fuels, from the old general cargo ship to modern container ships, and from a paper-based world to today's increasingly digital economy. All these developments have increased complexity in the shipping market, and all of them have presented challenges for dispute resolution. But the great strength of English law is its flexibility and the speed and ease with which it adapts to new conditions. That's largely due to the common law system of precedent, which allows the law to develop organically via small incremental steps to meet the current needs. In the maritime context, it's also due to the concentration of expertise and the number of shipping professionals of all disciplines who are based in London, and also to the policy pursued by English law and the English courts to support London as a leading centre for resolving shipping disputes. So, what are the specific challenges for dispute resolution today and tomorrow in an increasingly complex shipping market? I want to highlight three, and none of these challenges is unique to London. The first challenge concerns expertise. As the shipping market becomes more complex because of new technologies, new regulations, new ways of conducting business, there is a need for new expertise. And that applies, of course, to judges, arbitrators, and lawyers. But more importantly, it means there's a need for expert witnesses who can advise and give evidence about the new technical issues. Now, for a long time, it has been difficult to find expert witnesses who are prepared to give evidence in certain fields. A notable example of that is shipbroking. And the reasons are fairly well understood. There may be no shortage of people who possess the necessary expertise, but if they're currently working in the field, which may be a prerequisite for them to have up-to-date expertise, they may often be unwilling to give evidence against a party who they or their employer does business with. They may also be concerned about divulging market-sensitive and even proprietary confidential information. One can envisage similar types of problem arising in some of the new fields of expertise that will come to the fore in the next few years. Second challenge I want to highlight is cost, which is a perennial problem for maritime dispute resolution. Increasing complexity tends to lead to increased cost, but keeping costs down is critical to London's competitiveness as an international centre for maritime dispute resolution. Now, the English courts have taken a number of steps recently to control costs in court proceedings. They've introduced detailed and fairly onerous cost management regimes. They're currently running a pilot scheme aimed at limiting disclosure, which is a major source of unnecessary costs. And they've just introduced a new set of rules designed to curb the length and complexity of factual witness statements, which is another known problem area. Arbitration is by its nature less prescriptive, but a couple of matters deserve mention. Firstly, the LMAA has two specialised streamlined procedures, one for small claims and one, less well known, for intermediate claims, both of which limit the parties' recoverable costs, and those limits are designed to encourage parties to keep their costs down. And also, arbitrators have enthusiastically adopted other cost-saving measures which have come to the fore during the pandemic, including virtual hearings and electronic hearing bundles. And those measures can be expected to remain as permanent features of London maritime arbitration. And of course, there are other low-cost dispute resolution services available in London. Those include traditional mediation, newer forms of early intervention mediation, and dispute boards for resolving problems arising during the course of projects such as construction, shipbuilding, and offshore energy projects. And Ben will be saying more about that topic in a little while. The third challenge I want to mention is about the multiplicity of parties, which is another byproduct of an increasingly complex market. Take a case like the recent grounding of the Ever Given in the Suez Canal. Without going into the details of that specific case, an incident of that nature involving a ship of that type and that huge size can give rise to a vast number of related disputes involving the ship owner, its P&I club, hull underwriters, salvors, local authorities, time charterer, slot charterers, numerous NVOCCs, even greater numbers of cargo owners, their insurers, and various reinsurers, to name but some. Now, in an ideal world, as many as possible of these disputes would be determined in a single coordinated process. That would ensure consistency of results, it would avoid unnecessary duplication, and it would keep costs down. But in the real world, the process is usually much more fragmented. each individual contract is likely to have its own dispute resolution clause. That may call for litigation in the courts of England or elsewhere, or more likely it may call for arbitration in London or elsewhere, and it may incorporate the rules of one or indeed none of a variety of arbitral bodies such as the LMAA or the LCIA, to name but two. There's little that can be done about this type of fragmentation. It's an unavoidable consequence of the consensual nature of arbitration, the principle of international comity, and the terms of the New York Convention. But English courts and arbitral tribunals do have a few tools at their disposal to mitigate some of this fragmentation. The English courts have wide powers to consolidate and manage related cases where the English court has jurisdiction and to hear and determine those cases. And the English courts can also grant anti-suit injunctions to restrain foreign proceedings which are brought in breach of a jurisdiction or arbitration agreement. And of course, since the 1st of January of this year, they can now restrain proceedings even in the EU. Arbitrators' powers are far more limited because of the consensual nature of arbitration. But under the LMAA rules, arbitrators can order arbitrations which raise common issues to be conducted concurrently. And in the important case of Halliburton and Chubb, decided at the end of 2020, the UK Supreme Court approved the practice of arbitrators in maritime arbitrations of accepting multiple appointments in related cases without having to disclose that fact to all and sundry and without any suggestion of bias. So those are three of the broad challenges facing dispute resolution in an increasingly complex shipping market. With that, I'm going to hand over now to Ben.
Thank you, Tom. If I could get the slides up, please, then, Olga. Thanks very much. Yes, thank you, Tom. Thanks also to Maritime London and to Hill Dickinson for hosting this webinar and inviting me to speak today. Good morning, everybody. I work principally as an arbitrator, but was introduced to dispute boards a few years ago and have subsequently learned a fair bit about them and have received some training in their administration and practice. I'm not an experienced dispute board practitioner at this point in time. I don't think anyone in shipping is, but I plan to explain a little bit what they are and how they work and why I think there's a role for dispute boards in maritime contracts going forward. Dispute boards are a unique form of alternative dispute resolution geared towards complex projects and ensuring optimal project delivery. They originate from and are mainly used in the onshore construction industry. Offshore, in my view, obvious uses for them would be in contracts for the commissioning and decommissioning of offshore structures such as wind farms and oil rigs, and in shipbuilding. Of the various forms of dispute resolution, dispute boards are most closely related to adjudication. They're certainly not mediation or arbitration, nor are they intended to replace those forms of dispute resolution. In fact, most, if not all, contracts that provide for a dispute board also provide for arbitration or court litigation as the final recourse. Dispute board decisions may be binding and enforceable. Whether they are or not depends on the power given to them by the parties that appoint the dispute board members and which are reflected in the terms of reference when the dispute board is first convened. Dispute boards are independent, they're impartial, and they usually comprise of 1 to 3 members, all of whom have experience in the subject matter of the contract. Usually where the board is a multi-person dispute board, the members making up the dispute board have complementary skill sets. So, for example, one might be a specialist lawyer, one might have technical knowledge and experience relevant to the contract, and one might be a dispute resolution specialist. Dispute boards go by various different names: dispute review board, dispute avoidance and adjudication board, combined dispute board, being a few of them. The main difference between them is the authority that the dispute board is given, and whether they're empowered to give just non-binding opinions, recommendations and decisions, or binding ones. Dispute boards can be grouped into two categories: ad hoc and standing. Ad hoc dispute boards are formed after a dispute has arisen, and the dispute board is empowered to give a binding decision or ruling, so essentially to act as an adjudicator. A standing dispute board is formed at the commencement of the contract, before any work has commenced, and remains involved and up to date with progress for the duration of the project, usually by participating in regular periodic meetings, management meetings, which are anyway scheduled to take place. At those meetings and between them, the dispute board assists by giving, when asked, informal opinions and helping the parties to deal with unforeseen problems and that inevitably arise during the life of a project. If needs be, the dispute board also acts as an adjudicator and gives a binding decision on disputes that weren't avoided. So a standing dispute board plays a permanent dispute avoidance and resolution role for the entire project duration. I should emphasise here, though, that dispute boards are not intended to obviate the need for the parties to maintain their own project management capabilities, and the parties remain responsible for performance of their contractual obligations and project management throughout. The dispute board's role is a facilitative, governance-related one, where it provides objective third-party advice, recommendations or decisions geared towards achieving best for project outcomes. The reasons for having a dispute board could be said to be fairly obvious. Disagreements and disputes negatively affect time, cost and resources, which ultimately impact project outcomes. And the costs of dealing with them are often not recoverable. Not only that, but dispute boards sour goodwill and long-term relationships between the parties to the contract and tie up management resources. Left unresolved, disputes create a breeding ground for end of contract claims. The role of the dispute board is to assist to try and avoid all of that by assisting the parties to avoid disputes in the first place, and when that's not been possible, to act as an adjudicator and provide an interim decision, thereby keeping projects on the rails and moving forward. The dispute board's well suited to act as adjudicator at that point because they're seeing the claims in real time and aware of the background. This has got to be one of the key advantages of a standing dispute board over traditional adjudication or ad hoc dispute boards, where the adjudicator is dropped in with no prior involvement or knowledge of the project before then. Adjudicating the dispute is a merit-based process, not unlike an LMAA small claims procedure, which maintains integrity and procedural fairness. The dispute board's decision is based on factual records, project documentation, all of which is available because it's taking place in real time, and the dispute board provides reasoned and detailed findings by experienced and independent experts. And whilst the losing party is bound by the decision, it's interim binding, meaning that most contracts provide for final resolution of the dispute to be by arbitration or court litigation. But that process takes far longer. It does not take place in real time. So that's more of a picking up the pieces exercise at the end of a project, where dispute boards are geared towards keeping the project moving. Other benefits that a dispute board gives to the project are familiarity with the project, a dispute avoidance attitude. Dispute boards encourage and instill a sort of positive and collaborative relationship between the parties and are proactive. Also, the parties choose the dispute board members and maintain control over much of the dispute board process, so they're not ceding control. What they're doing effectively is committing to transparency, to good governance, and the best for project outcome, which ultimately is what the dispute board is there to achieve. Here's a slide for those of you that like statistics. The Dispute Resolution Board Foundation, DRBF, is a non-profit organisation formed in 1996, dedicated to promoting dispute boards for the avoidance and resolution of disputes worldwide. They have over 1,000 members from more than 70 countries globally, and they're an excellent resource. In a 2018 study, they captured over 2,920 completed projects where a dispute board had been used, and a total construction value of in excess of $280 billion. According to their analysis, over 85% of disputes which were referred to the dispute boards did not go on to be arbitrated or litigated afterwards. So the dispute board's decision was accepted and put an end to the matter. International funding agencies are big advocates of dispute boards, and the World Bank and other multilateral development banks are increasingly requiring dispute boards as a condition of funding. So they're slowly becoming more common and mainstream. That said, to my knowledge, they're rarely, if ever, used in shipping currently, and I think there are several reasons for that. One is a lack of awareness of them, which is bound to improve over time as dispute boards become increasingly mainstream. Another, though, is inertia, the tendency of people, and by that I mean the parties to the contract and their legal advisors, to do nothing and to keep things unchanged from one contract to the next. I think that's likely a major factor holding the advancement of dispute boards back. A third reason, I think, relates to perceptions of cost. At the outset of a project, budgeting for the costs of a dispute board might be unpopular when relations between the parties are good and everybody's optimistic about delivery of the project. And I expect that's a key reason why parties to construction contracts often fail to appoint a dispute board even when their contract provides for it. But actually, when you weigh up the cost of the dispute board against the cost of litigation and arbitration, the dispute boards can actually be viewed as a saving, not only financially, but in terms of time and resources, which is also absolutely critical in any project. So with decommissioning of offshore structures, commissioning of wind farms being hot topics, and with ships and shipbuilding becoming increasingly sophisticated, I suggest that these are undoubtedly the sorts of contracts and areas of maritime ideally suited to having a dispute board. The LMAA recently added a list to its website of its full and aspiring member arbitrators who are willing to accept appointment onto dispute boards. And this list comprises around 25 arbitrators and mediators with a broad range of specialist marine and maritime backgrounds, including naval architects, marine engineers, master mariners, even nuclear submariners, just to mention a few. And the LMAA have another list of over 70 of its supporting members. So there's no shortage of interest and arguably expertise. The challenge, I think, is to raise awareness, tackle the inertia, and equip appointers with a cost-benefit analysis that's compelling enough for them to get on board. If this has piqued your interest and anyone would like more information, then I encourage you to check out the DRBS website. They're a membership organisation, but membership is not overly expensive. It's an active membership, and they host training and awareness seminars for members and non-members alike. So thank you for listening. With that, I will pass you over to Lewis.
Well, thank you, Ben and Tom, for your very, very interesting presentations. And good day to you all. And thank you also to Joss and Maritime London for hosting us today. I'm going to talk about an issue that really Tom has already touched on, which is cost and expense, with specific reference to expert evidence in arbitrations. Now, the way in which arbitrations normally deal with experts and in court is that experts are cross-examined, sometimes vigorously, sometimes aggressively by counsel, who seek to disprove or show that the expert's theories are incorrect. This is something that could change by the use of a technique called concurrent expert evidence, or hottubbing, a technique which has come to us from Australia and not, as you might think from its name, from California. And instead of the experts being cross-examined separately, concurrent expert evidence works in this way. The experts are all placed in what you might call the witness box, or in front of the tribunal together. They're then examined together, and this examination is led by the judge or the arbitrators, rather than starting off with an adversarial cross-examination. So it's a very different process. And there are procedures now which are being put in place to make this process work. The Chartered Institute of Arbitrators has prepared a protocol for a concurrent examination of both witnesses of fact and experts, and it's also embodied in the CPR, the Civil Procedure Rules for court proceedings. So how do these techniques work? Well, first of all, it's meant to be totally flexible. That means that if for any reason the procedure of concurrent examination isn't working, then the judge or the arbitrators have got the power to change it and revert to a traditional cross-examination system or deal with it in some other concurrent manner. The process is kicked off with an agenda, and that goes back to what the experts produce when they have their meeting. Normally, experts prepare reports, then there'll be a meeting of experts, which the experts will set out the points on which they agree, hopefully plenty, and disagree, hopefully very few. And working from those points of disagreement, an agenda can be prepared. The experts are then all placed, as I say, in a witness box or in front of the arbitrators in preparation for the process. And it is initiated by the judge or the arbitrator, who leads a series of questions to the experts in relation to the issues that are on the agenda arising from the points of disagreement. And the flexibility of the process can be seen in this way, that not only does the judge or arbitrator lead that process, but there is scope for him to ask the experts to comment on each other's statements and even to ask each other questions. So the intention is to produce a synthesis of the expert evidence for the decision maker in the proceedings to then reach his conclusion. After that process, after that stage in the process, counsel are then let loose on the experts, and they're allowed to ask questions to clarify issues or to seek to get further information from any of the experts on any of the issues which have not been dealt with properly. But the intention is to keep this all within the agenda and not allow the experts to go off into areas that are not within the focus of the actual procedure. After counsel has completed his questioning, the judge then would normally summarize the evidence that the experts have given and ask them to confirm that he's got it right or correct anything that they think is wrong. So a very different procedure from what we would normally see. And what are the advantages? Well, it certainly must avoid the same question being put to different experts at different times. And it would seem to me that it would allow areas of agreement and a disagreement to become recognized quite quickly in the procedure. I think it would also tend to restrain experts from becoming too aggressive in some of the things that they say and giving theories that they perhaps could not support when they're sitting next to one of their peers who may well criticize something that is less than correct. It is certainly going to be less confrontational than you would normally expect to see in terms of cross-examination of experts. And that is an advantage. But perhaps most of all, it saves time at the actual trial, which is one of the most expensive parts of the procedure. So there seems to me to be a whole range of benefits from this process, but there are also disadvantages. For the clients and their lawyers, there may be a feeling that they're losing control of the way in which the evidence is presented, because instead of leading cross-examination, they have to sit back and watch the judge deal with it in his own way. And there is an important feature here, which is that there is a significant amount of front loading. In order for a judge or the arbitrators to lead the expert evidence, they've obviously had to spend some time considering it and that will increase the preparation time that judges and arbitrators have prior to a hearing. Now, as regards judge time, that effectively comes free. The parties don't pay for the time that the judge spends working on the case, but of course they do pay for the arbitrator's time. So if there is an increase in arbitrator's time, that will be an increase in the costs. But I think even so, it would be balanced out by the savings in time if the process works well. Another disadvantage, however, is the need to make sure that the process is seen as one in which the parties have been given a fair opportunity to present their case, and that there is no potential perceived or real even bias on the part of the tribunal. And that can create a difficulty. If there is a procedural irregularity, it can lead to an expensive and time-consuming challenge in the courts. And I think this is particularly a problem for arbitrators who themselves do have technical expertise, that they should not allow their own views to colour the way in which they deal with expert evidence, which might give some suggestion that perhaps they are not giving all the parties a fair hearing. The worry would be that if there is a lack of preparation by the judge or the arbitrators, the process would become a little less manageable and not produce the results that are sought. And there is also a concern that if you have a very senior expert or a domineering personality in the panel of experts, he may overrule or take control of the proceedings to such an extent that a fair resolution is not found. And also, it could be a difficulty with the multi-party cases. As Tom mentioned, there are many cases with multi-parties, and often you can see this in charter party chains. And if there are several experts, it might be a less easy process to manage, although still, I think, less time-consuming than the cross-examination of several experts separately. And finally, I think it does create a problem for the legal team, because where the party's expert is sitting in the with the other experts in the hot tub, counsel and the lawyers do not have the benefit of their own expert to help them with the cross-examination and questioning of the opponent's experts. So that, I think, does suggest that counsel and the lawyers will have to spend even more time than they do now in preparing thoroughly for the hot tub section. But I think that the advantages here certainly seem to me to overweigh the disadvantages. The reaction to hot tubbing, which is being tried in the courts and in arbitration, is generally very favourable. And I think in terms of the issues that we face today, which are cost and expense and delay, the answer is that the procedure, when properly run, is almost certainly going to assist the parties get a fair resolution, save costs, and save delay. And we have throughout the common law world a body of some very excellent experts who all respect their duties to ensure that the proper evidence is given and that their duty lies to the court or tribunal before whom they are giving evidence more than their clients. And I think that with the buy-in from the courts and from the arbitrators, and I'm very confident that that buy-in is going to take place, that we will see an increasing use of concurrent expert evidence, that clients will feel that they are getting a fair hearing, that they are saving costs, and they are getting the right answer to their questions when they get into a dispute. So it's something that I think we can look forward to in the same way that mediation was once a new kid on the block, but now is a very familiar part of any litigation. And I think going forward, we will see the hot tub more in evidence in dispute resolution, both in England and abroad throughout the common law world. So thank you all for your attention. I hope this is of interest, and hope that I'll see some of you in the hot tub before too long.
Lewis, thanks very much for that presentation. And if I could invite the fellow panelists to re-enter the screen, which you all have done. I think that was a really fascinating overview in terms of where English law is currently, and also English law practitioners in terms of their pragmatism in dealing with some of the issues which we are experiencing at the current time. I'd like to start off with just raising a point from Tom's presentation, in that you stated that cost, expertise, and the multiplicity of parties were perhaps the three main issues in regards to dispute resolution moving forward. And one thing I'd like to explore is whether those three issues are perhaps mutually compatible, and are we pursuing cost-saving exercises perhaps at the expense of quality, which might be needed when we are dealing with increasingly complex cases as we deal with the challenges moving forward. And Tom, I'll start with you on that one, but then open it up to the rest of the panel.
Well, I mean, I think you make a very important point. It is a problem that courts and arbitrators have been grappling with since the dawn of dispute resolution, and it continues to be a problem. There is always this tension between keeping costs down, which is an important part of maintaining the competitivity of a dispute resolution centre like London, and getting the Rolls-Royce service that you would like to be able to offer. And I think that at the moment, London in general is getting it just about right. One can only judge that by seeing, what's happening in the market, whether people are abandoning London to go elsewhere. I did read a couple of days ago that Singapore has now drawn level with London as a seat for international arbitration. So we always have to be aware that there is a competitive world out there, and that there are other people breathing down our neck. I don't have an easy answer to the question. It's simply one of those baked in problems that we have to keep alive to and make sure we're striking the right balance all the time.
Lewis or Ben, sorry, I'll pass over to you.
Yeah. I mean, I would just add to that. If we look at the sort of technological innovations that are taking place, and and the new technologies that are being asked for and being investigated, one thing those innovators know already and have voiced is the fact that the customers won't compromise on quality. So if yes, you want clean ships and you want zero emission propulsion systems, but the customer is not willing to compromise on the speed of the ship and the performance. And I think the same can be said of legal services. The customer shouldn't expect to compromise on quality, and I don't see why there should need to be such compromise, personally.
Lewis, have you got anything to add there?
Well, I do accept as someone on the receiving end of costs that they are often perceived to be high, but they're always terrific value, I've got to say, no matter how big the bill is. But the alternative resolution procedures like mediation, early intervention mediation, are all available. They can be run in conjunction with litigation, and parties can take a commercial view on whether or not they want to do a deal or whether they want their day in court. The reality is that the day in court is expensive. It does take some time to get there, but it does generally provide the right answer, although at a cost. So you can take it whichever way you want it, but there are alternatives if the money is the issue.
Yeah, thanks for that response. And I think just to build on that a little bit, Lewis, when you went through hot tubbing, I'm interested to get a bit more detail on that in terms of, can hot tubbing firstly replace the rigor of cross-examination by counsel, and Tom might have a view on that. But secondly, does it mean that it's only really specific is it only really applicable in very specific circumstances?
Well, I think the first point is that that hottubbing is in relation to a decision, an agenda that's been laid down in relation to what the expert issues are that have to be decided. So it is specific, and I do think it is capable of saving time and money in the short term and in the long term. So I'm sorry, your first question. Sorry, Joss. Just going back to the first issue.
Yeah. So it was a two-part question. One, can sort of hottubbing replace the rigor of cross-examination? And the second part of it is it only really applicable in specific circumstances?
Right. Sorry. Yeah. Well, the answer, and I'll be interested to hear Tom's views on this as well, because they may or may not be the same as mine. It is not going to replace cross-examination, because at the end of the session, the barristers, the counsel, or lawyers have the opportunity to put their questions to all of the experts at the same time, which I think some counsel, I think, would find it quite an interesting and a helpful way of eliciting the evidence. So it doesn't replace it, but it might well short circuit that process by focusing on the agenda, letting the judge or the arbitrators take the experts through the process, and then leaving counsel, as it were, I hesitate to say it, mop up, but certainly deal with any of the issues that are still alive at the end of that process. And I'd be interested to hear Tom's position on that as well. Thank you.
Well, I can see that there are some advantages from hottubbing, but I would describe myself as a hottubbing skeptic, based on my own limited experience of it. I think the name hottubbing tells you quite a lot. It conjures up the images of an arbitrator and the experts donning their swimming trunks and climbing into the hot tub for a friendly chat. I think that highlights my issue with it, which is that it undermines the very important role of cross-examination in an adversarial system such as the one that we have in England. Because cross-examination takes many forms, and there are some cases in which it is legitimate and appropriate for an advocate in a case to challenge the expertise, the thoroughness, the objectivity, and rarely even the honesty of the other side's expert. That can be perfectly legitimate. The problem with hottubbing is that the arbitrators tend to get into the hot tub on an underlying assumption that both the experts are real experts, they're both thorough and objective and honest, and that the arbitrator's role is to just tease out by discussing things with them in a fairly non-confrontational way where the truth lies on the substance, which is fine in theory. But where you've got a case which involves challenging the thoroughness, the expertise, the objectivity of the other side's expert, that can only be done by cross-examination. My own expert, who will be advising me and giving me the basis for those sorts of challenge, can't do that job, can't do it in the hot tub or in the box, because that's not his job. He's not an advocate. So one risks the parties coming out of the hot tub with my case not really having been put to the other side's experts. And Lewis says, well, there's a mopping up operation afterwards. That in my view is not really adequate for two reasons. One is that generally speaking, no matter how efficient the tribunal is in conducting the hot tubbing, there's not going to be a huge amount of time left, not as much time as the advocates want and think they need for that second stage cross-examination. And then more fundamentally, when the experts emerge from the hot tub, the arbitrator will very often feel, well, my job is done now. I've worked out the right answer. I'm feeling rather pleased with myself. I've decided that the other side's expert has got it basically right. And I may not be very receptive to that nasty counsel on the other side asking my new best friend all these rather difficult questions. So I think that from the point of view of the parties, they can end up feeling a little bit shortchanged by the process, and it is really quite difficult to build in a structure which prevents that risk from arising.
Ben, you're a relatively new arbitrator from a commercial background. Do you have an opinion on hot tubbing as a form of questioning expert witnesses?
I don't have an opinion as firm as either Tom's or Lewis's. I've not experienced hot tubbing in any of the hearings that I've been involved in yet. It's not been suggested or proposed by either of the parties. I mean, I can see the advantages and disadvantages, the pros and the cons. I mean, and I don't have a firm opinion. I mean, you are to an extent removing the sort of autonomy, power from the parties as to procedure by taking the responsibility on as the arbitrator. You're sort of ceding control, or the parties are ceding control to an extent by putting interrogation, for want of a better word, of the parties over to the arbitrator, and in that sense, it goes a little bit to fairness or unfairness. So to my mind, there's that question of it, but no, I don't really have a firm opinion. I think it is ultimately for the parties to decide whether they think hot tubbing is right, depending on the circumstances of that particular case.
Yeah, and I think that goes back to, I suppose, the point that Lewis made at the beginning in terms of, you know, it's about the parties agreeing what the most appropriate form of cross-examination is in regards to that particular case. Now, we are quickly running out of time, unfortunately, and there's a huge amount of stuff that we could talk about. And as Tom mentioned, I feel that most of the drivers changing the sector at the moment are probably underpinned by the imperative to decarbonise, and there's probably a wider question there that we can ask if we get the time. But there's two questions that's come in on the chat. Firstly, from Jeffrey Bloom, which directly correlates to the discussions taking place at the IMO this week. And that's whether a reduction in power we could see an increase in casualties as vessels are unable to power themselves out of potentially dangerous situations. I'm not sure, Tom. Do you have a view on this? I mean, it's quite a technical question, I suppose, but I don't think there's any harm in having a crack.
Yeah, I'm not aware of this proposal, but if the proposal is that all existing ships take some sort of 40% cut in their power output, I think that sounds a bit crazy for the reasons that Jeffrey highlighted in his question. Whether more generally there are devices or technologies that can be fitted to ships to reduce their power output in certain situations while retaining the necessary safety margin that Jeffrey mentions, that doesn't seem to me to be quite such an irrational suggestion. In fact, it seems that it may be a good suggestion. But with all these things, one can't simply look at the carbon and the decarbonisation aspect. One has also to look at the safety aspect. And I would have thought that if that sort of proposal were taken forward, then it would be looked at very carefully from those perspectives, and rules and the involvement of the classification societies would be central in working out when and to what extent that sort of measure could be implemented.
Yeah, thanks for that, Tom. I think that largely sort of coincides with Jeffrey's point. And just moving on, Charlene Roberts has asked on the chat regarding the sort of electrification of propulsion systems in vessels, and whether bigger vessels are likely to undergo a similar process. Obviously, Ben, you were a competitive shipbroker before becoming an arbitrator. Do you have a view there?
Yeah, yes. I mean, Charlene Roberts is right. The battery technology is geared very much towards short sea, smaller vessels. You would need a ship the same size or larger to house the battery, when you get it to sort of larger size tonnage. So there is that limitation currently, based on the technology and the battery technology that's out there. I think they're constantly innovating, constantly working on increasing the performance and capacity of batteries. But it sounds like we're a long way from batteries being the entire solution for the bulk of the tanker and the dry cargo fleet. They're looking at other things like wind technology. There's a lot of companies, or several companies out there now with different forms of wind technology that are also not the whole solution, but they do think that they can reduce fuel consumption by up to sort of 30-40%. If it's a new built ship with a fully integrated wind propulsion with the main engine, then they claim to be able to achieve far higher savings than that. So there's a lot going on in wind, and I think there's a sort of consensus building generally that there's not going to be one solution. There's going to be several different technologies and different solutions that make up the whole package, and that's synthetic fuels, different types of fuels, wind, battery, and different things. And just leading into a question that you haven't asked, but just going back to dispute boards, I think that's also that is where dispute boards could play a role, because we're talking about a lot of collaboration and new technologies and a lot of integration of different technologies, which is highly complex and will lead to all sorts of issues along the way that some can be foreseen and others can't. So I think that's where dispute boards could play a role, because it's kind of new ground for everybody, and you need some impartial third party assistance really to try and achieve best for project outcomes.
Tom.
Just to add, following on from what Ben was saying, I think it's right that a number of different technological solutions are likely to be likely to make it through past the R&D phase to implementation. But of course, the more different new fuels one has to deploy, the more of a challenge it is for the infrastructure rolling that out across the world. If you've got to be able to supply ships with ammonia and methanol and LNG, then that makes life more difficult. So there is also a vested interest in the industry finding one champion, which is going to be the main solution for most of the deep sea fleet.
I think it's a really interesting point that we've touched on there, and I think what it points to is the fact that the industry is going to have to adopt a number of new technologies, new fuels, which the sector hasn't seen before. And in that context, and perhaps moving it back to dispute resolution, are we moving into a time, particularly if you combine this with autonomous vessels, etc., are we moving to a time where perhaps the precedent doesn't exist in English law to deal with the new technologies coming down the track? And Lewis, I'll start with you on that one.
Well, I mean, yes, precedent is looking backwards, and we're now looking forwards. I think the techniques that we have developed for resolving disputes, whether amicably or through litigation, will lend themselves to the future disputes, no matter how complex the issues are. And I think that I have my view about hottubbing and techniques like that, but I also have a very strong view that mediation is a way forward. And I think also the boards that we talked about, that Ben's mentioned, are also techniques that we need to look at. And we have to have this holistic approach, perhaps try and avoid disputes, but if they, if they are unavoidable, make sure you've tried all the avenues first before you end up in court.
Tom, Ben, do you have anything to add there? Can you?
I agree with Lewis. I think that obviously there'll have to be new legislation, new international agreements covering these new technologies, but the basic techniques of English law will remain the same, and I think they're sufficiently flexible and adaptable to continue providing very good solutions to disputes in the future.
Absolutely. Sorry, Ben.
I agree.
I mean, we're now running over time, I suppose. But Ian Gaunt put a point of perhaps clarification in the chat, which has been a subsequent of some further comments. Of course, whilst Singapore may be making hay in the wider dispute resolution market, I think it's fair to say that the LMAA are still largely dominant in shipping dispute resolution, just to put that point out there. Now listen, I think what I'd like to do now is just sort of go round the panel as we look to close, and just see if there's any final points that the panel would like to make, and then we'll look to close off the session today. So in order of presentations, Tom, I'll start with you.
I'd just like to pick up on a couple of other points that Ian Gaunt made in the chat. What do I think about tribunal appointed experts? I'm not a fan for the reasons that you can guess. What do I think about the practice of the parties getting together after the hearing and seeing if they can settle? I'm a big fan of that.
Ben?
Thank you. Yeah, no, I think interesting points raised. For me, it's been a very interesting conversation, and I think, as is often the case, that the right dispute resolution it's very much dependent on the facts and the case that in front of you. But I certainly think that London and the UK as a whole, as a maritime cluster and as a legal cluster, certainly punch far above their weight, have done for a long time, and will continue to do so. And I think the legal services are evolving as needed, along with the law and along with the innovations which are taking place.
Ben, thanks very much for that vote of endorsement there. I think it's a view that we all share. And Lewis, over to you.
Well, I just like to echo Tom's point that court-appointed and arbitrators-appointed experts, unfortunately, isn't the way forward. Even if the Supreme Court does allow itself nautical assessors to sit with it when it deals with, I see that's a controversial point already, when it deals with collision cases like the Ever Smart. The elder brethren obviously are unimpeachable, but let us just hope that Tom's point about experts is not going to be a factor, that people will not be putting forward experts who do not have the expertise or that do not have the ability to deal with the issues. And then maybe there's a possibility that the cross-examination can be dealt with in the mopping up rather than in the first instance. But it does require all the parties to play their part to make that part of it work.
Lewis, thanks for that, and again, thank you to all of the panelists for what I thought was a really interesting discussion. I think, as we've evidenced in this discussion, whilst there are some significant changes taking place in the market at the moment, English law and English law practitioners are certainly rising to the challenge and being pragmatic in terms of how we look to resolve these challenges that exist in the market. I wish we had a bit more time. I've got at least 10 further questions which I could have asked the panel today, but alas, that is the nature of things. Thank you to all of the attendees. As I said at the beginning, we'll be sending a recording of this webinar out as soon as possible. But for now, I'd like to wish you all a very good weekend. Enjoy the weekend of sports, particularly if you're in Europe this weekend with the Euro starting. I haven't checked the cricket score card, but hopefully we're in for a good weekend of cricket as well. And I will leave you all there. Have a lovely weekend, and we'll see you all soon. Bye bye.